Mr. Church, Mr. Seaslift or Seslift, I believe, is joining remotely today. Is that correct?
That is accurate.
Here. While we're waiting on that, do you have another client that's ready to go?
We have, I think up next, Mr. Beebe.
Okay. We'll go on record in People versus Nathan. This is case number 236626. The record should reflect Mr. Beebe's present here in court today. If I could have counsel put your appearance.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Beebe.
Okay. And Mr. Trush, can you tell me where things are at with this file today?
Thank you, Your Honor. We are on receipt of an offer from the prosecutor. The offer actually encompasses this file as well as I think a domestic violence file that's still down in the district court. That offer would be, though, that in this file, if Mr. Beebe pled to a possession of methamphetamine, the enhancements would be dismissed. A condition of that is also that he pleads to a domestic violence first offense or resolve the domestic violence case, which is 23-42315 SM. And also as part of that, we would not be seeking admission into the drug court program. And I believe from my discussions that Mr. Beebe does want to avail himself of that offer.
Okay, Mr. Rolla, is that a correct statement of the plea offer?
It is, Judge.
Okay. And Mr. Beebe, have you had a chance to talk to Mr. Church about this plea agreement?
Yes, sir.
Okay. Is that how you want to proceed with that?
Yes.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Mr. Beebe, you understand that the maximum possible penalty that you could face for possession of methamphetamine is up to 10 years and or $15,000 fine?
Yes.
Are you currently on any kind of probation or parole?
I am on probation.
Okay.
Roughly quite a bit left.
Okay. Is your agent aware that you're entering this plea today?
Yes.
Okay. So you understand that you could face additional penalties for violating your probation by pleading guilty? So with all of those things in mind, how do you want to plead to that charge of possession of methamphetamine today? Okay, I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all those rights by pleading guilty today?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we discussed here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this charge? Okay, so the date that I have for this is September 19th of this year, 2023. Is that the correct date?
Yes.
On that day, were you here in Otsego County?
I was.
While you were here in Otsego County, did you have possession of some methamphetamine?
Yes.
Did you know that that's what that was?
Unfortunately, yes.
Did you have any legal right to have that at that time? Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge.
Mr. Trush?
I am satisfied, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been stated on the record?
No, Your Honor.
Mr. Trush?
I'm aware of none, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court roll on the tape of this plea?
We are, thank you.
I am satisfied.
Okay, Mr. Beebe, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. You're going to meet with Mr. DeLeo here to set up a pre-sentence interview, and then we'll set this for a sentencing hearing. It's important that you stay in touch with Mr. Trush prior to that hearing. Mr. Rolla, is there anything else that we need to address in this file today?
Not in this file, thank you.
Mr. Trush.
Hey, Your Honor, I just want to make sure that we have a clear record insofar as that plea offer is contingent on a resolution in a misdemeanor case. I just want to make sure, Mr. Beebe, you understand, if ultimately that resolution of that misdemeanor case does not happen, you understand the prosecutor may have the ability to withdraw that plea offer he's made to you.
Yes.
Yeah.
Thank you for that record. That's all for today, Mr. Beebe. Thank you. All right, sir, on the Samsung device there, if I could have you unmute yourself, please. Thank you. Can you tell me your name?
Keith Guinea.
Mr. Guinea? Okay. Oh, he's got different counsel. Okay, Mr. Guinea, we have your hearing set for 10 o'clock. So you can, I'm going to put you in the waiting room. You can stay connected or you can sign back in at that time. Okay.
Oh, okay. Thank you.
Thank you. Okay, Mr. Trush, do you have Mr. McLeod present?
I do not, Your Honor. He contacted the court this morning, and then I think subsequently the court instructed him to get in touch with me. He did contact the office, but obviously I'm not there. He indicates that he has a positive COVID test. Frankly, Your Honor, this is the first contact I've had with Mr. McLeod since the bind over from district court.
Okay. So the court will set this for Mr. McLeod's case for a show cause. When you have contact with them, let me know that he's going to need to bring some kind of documentation of that positive test result, or the court may find him in contempt and sanction him by revoking his bond. And of course, that he needs to be present for the next hearing. Mr. Rolla, do people want to make any record on that?
Judge, I just indicate that, again, if this doesn't show up next time, there was a plea offer that was extended. If he's not here, he can't accept it, and it may wind up being revoked.
Okay, thank you. All right, sir, on the iPhone, can you tell me your name, please?
Michael Seslick.
Mr. Seslick, okay. We'll go on the record in People versus Seslick. This is case number 236612. Mr. Seslick is appearing today by video with prior approval of the court. And if I could have counsel put your appearance in.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Seslick.
Okay, and how did we want to proceed today, Mr. Trush?
Thank you, Your Honor. The prosecutor has extended an offer to us, but the discussions in regards to that plea have been contingent on Mr. Seslick making a restitution payment. He's in the process of putting that money together. Actually, he's selling some real property in order to raise the funds for it. I would ask the court to consider giving us 90 days to get that restitution paid, and we would anticipate that we would be in a position to take advantage of that offer at that time. And obviously the 90 days is partially because sales of real property have some time limitations.
Understood. Okay, Mr. Rolla, do people have an objection to that?
Judge, I believe there's like $5,000 in restitution. In light of that, we don't have an objection.
Okay, so the court will set this for a status conference plea hearing in about 90 days. Obviously, Mr. Trush, if you're ready to proceed earlier than that, then just let my office know and be happy to schedule it. And then otherwise we'll proceed at that time. Mr. Seslick, were you able to hear all of that?
Yes, sir, I was.
Do you have any questions about how we're going to go forward?
No, no, sir. As long as if I come up with it within 90 days, we can schedule before that.
Okay. Yep. And then just make sure that you stay in touch with Mr. Trush so that you're up to date, and he is too, with what's happening with your case. Okay.
Yes, sir. Will do.
Okay. Thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
All right. People versus Jesse Thomas, case number 236608.
Record, John, my phone got people.
Thank you.
I'm sorry. Record should reflect Mr. Thomas is present here in the courtroom. Go ahead, Mr. Trush.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Thomas. Your Honor, this is actually very similar to the last case. There's been some discussions with the prosecutor in regards to this case as far as potential offers. There is about $3,000 of restitution. Mr. Thomas is working 2 jobs right now to get those funds together to get it taken care of. I would suggest to the court giving us a date. I think probably about 60 days out on this one would be sufficient for us to be in a better position to tell the court whether or not we have an agreement or not.
All right, Mr. Rolla.
Judge, with the prior matter, people have the objection.
Okay. So we'll set that for a status conference plea hearing in about 60 days. So Mr. Thomas, as I indicated to the previous individual, just make sure that you stay in touch with Mr. Trush so that we're all on the same page with how things are going in terms of payment of restitution, and we'll go forward at that time in about 60 days. Yes, sir. Did you have any questions at all? No, sir. Thank you. That's all for today.
I know that we are ahead of schedule, but Mr. Urick is here if the court wanted to take care of his matter.
Sure. Yep. Mr. Urick, you want to come forward, please? This is case number 236634. People versus Jeremy Urick, case number, I'm sorry, I didn't say that. Mr. Urick's present here in the courtroom today. But you have counsel put your appearances on.
For the record, John, I go back to people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Urick. Your Honor, this is our first hearing up here in circuit court. Mr. Urick and I have had some pretty detailed discussions about what the plea offer is, what that might look like as opposed to what a trial might look like on this. Mr. Urick has requested 30 more days to consider that plea offer.
Mr. Rolla.
One more consent. Judge, in light of the nature of the plea agreement, we don't have an objection to a short adjournment. I don't think though that we need 60 or 90 days.
Okay. Yeah, I think that 30 days is a reasonable amount of time. This was just found over only about a month ago. So the court will set this for a plea hearing status conference at that 30-day mark. So Mr. Urick, just make sure that you stay in touch with Mr. Trush.
Yes, sir.
And that when we're here on that next hearing, just make sure that you're ready to have a decision on entering into a plea agreement or proceed to trial. Okay.
Yes.
Mr. Roll, anything further on this file today?
No, Your Honor, thank you.
Mr. Trush?
Nothing further.
Okay, thank you. Okay, our next hearing is set for 9:30. That's a sentencing. That's a remote hearing. Take a recess and come back on the record at 9:30. Deputy, if you want to let the jail know if they want to put Mr. Splan in the Polycom room, we can take them too, for him, you know. Mr. Splan, sorry. Okay, Mr. Brown, we're waiting for Department of Corrections with Mr. Logan to connect, and then we're getting Mr. Splan, the 945. I think he's lodged here in Otsego. We're getting him in the Polycom room. Okay, Mr. Logan, are you able to hear me okay?
Yes, sir.
Okay. All right, we're on the record in People versus Logan. This is case number 236-582. The record should reflect that Mr. Logan is appearing today by video from the Department of Corrections. This is the date time set for a sentencing hearing in this case. If I could have counsel put your appearances on.
For the record, Your Honor, Mike Roll, on behalf of the people.
Larry Brown on behalf of Mr. Logan.
Okay. And again, this is set for a sentencing hearing today. Mr. Logan, were you able to go through the pre-sentence report with Mr. Brown and talk to him about that?
Yes, sir.
Okay, Mr. Brown, are there any additions, deletions, or corrections that need to be made to that report?
Just one very minor one, Your Honor. On the SIR, it lists the crime group as public trust. That should be controlled substance.
Okay, any objection to that change?
No, Judge, I was gonna ask the same request, make the same request to the court.
Okay, we'll have that corrected. Any other changes, Mr. Brown, from your side?
No, Your Honor, and no challenge to the scoring.
Thank you. Mr. Rolla, do the people have any corrections?
No, Your Honor,
Any challenges to the scoring?
we do not.
Anything on behalf of the people for allocation today?
Briefly, Judge, the defendants in the Department of Corrections now until at least November 2026 on this Calcasket delivery of methamphetamine charges. He was out on bond at the time of the instant offense before this court for felony controlled substance charges. The ones he's now been convicted of and sentenced on Calcasket. He was the leader of a group of defendants selling meth. His guideline range is 5 to 23 months up to 40 years. There's a recommendation of 18 to 40, 18 months to 40 years with 2 days credit, which would run consecutive to his Calcasta sentence as he was. I think that's an appropriate sentence, and I'd ask the court to oppose the same.
Thank you. Mr. Brown, anything on behalf of Mr. Logan today?
Your Honor, Mr. Logan is only 31 years old. He does have a high school diploma, so he did graduate high school. He did have a very good work record. He was working in the oil fields for about 9 years. So there is a lot of potential here for him. Hopefully, while he is incarcerated, and this is not a minimal incarceration, it's 4 years and 2 months that he is going to be sitting there. So this is going to be a lot of time for him to evaluate his life, especially at his young age. This is going to be time for him to take advantage of anything that the prison would offer, because he does have that potential, and he has shown that potential. We know what drugs can do. Hopefully this will be a time of reflection for him. And so I would ask the court to adopt the recommendation and run it concurrently.
Thank you. Mr. Logan, was there anything you wanted to say today?
I got 4 kids at home that are missing their dad, and I would really appreciate the concurrent sentence.
All right, thank you. I did have a chance, Mr. Logan, to review the pre-sentence report prior to the hearing today. And so I'm familiar with the facts of what bringing before the court on this particular charge, as well as kind of your other issues that have gone on over the past couple of years, your current sentence out of Kalkaska, and your background in general. And taking all those things into consideration, certainly your activity in your role in providing methamphetamine, bringing it to this community, providing it to other people within the community is something that the court has an interest in punishing and deterring. But I agree that with Mr. Brown that there are some mitigating factors here as well, including your age, including that this is your first prison sentence. In the past, probation wasn't successful, but this is a different type of incarceration. And so that, along with your positive work history, high school diploma, I think there are certainly some, and your age, there are certainly some opportunities for rehabilitation here. And so while the court does have the discretion to run this concurrent because of your bond status, I think given your current sentence along with this one is sufficient to address those concerns of punishment and deterrence, but also leave open that possibility for rehabilitation to allow you to get out and continue working and supporting your family. So all of that being said, I think the recommendation is a fair recommendation. It's reasonable, it's within the guidelines, and it accomplishes the goals of sentencing. So the court is going to follow that recommendation. The court is going to sentence you to 18 months to 40 years in the Michigan Department of Corrections with credit for 2 days served. The court is going to make that concurrent to any sentence you're currently serving. Restitution in the amount of $350 that's payable to the Otsego County Clerk to be dispersed to Straits Area Narcotics. A crime victim's assessment of $130. Court costs of $325. Attorney fees of $350. A DNA testing fee of $60 and a state cost of $68. You do have the ability to seek an appeal of this sentence. If you haven't already received it, you will be receiving some paperwork that explains to you what your appellate rights are, Mr. Logan, as well as how to request a court-appointed lawyer to help you with any appeal. Mr. Rolla, is there anything else that you need to address on behalf of people today?
No, Your Honor, thank you.
Mr. Brown?
Nothing further, thank you.
That's all for today's hearing. Mr. Logan, you are remanded to the custody of the state at this time, and the court is going to go ahead and disconnect at this time. All right, hearing set for 9:45, People versus Eric Splan. This is case number 2365. And if I could just have both counsel put your appearances on, please.
For the record, Your Honor, my phone bill.
Larry Brown on behalf of Mr. Splan.
So this is set for a status conference today. I had listed in my docket that he was lodged. Court officers informed me that he did bond out of the jail. So he's not in the jail. Again, this was set for 9:45. It's now slightly past that time, but Mr. Splan is also not present here in the courtroom today. Mr. Brown, have you had any contact with him?
I have, Your Honor. I spoke with him on the 18th. Not sure if he was incarcerated at that time or not, but I did speak with him on the 18th. I'm unsure what the issue is.
All right, I'm just checking to see when this was set for a hearing today. All right, so Mr. Splan was given notice of the hearing today while he was lodged back on October 20th. Mr. Rolla, do you have any position on how to go forward today?
Judge, obviously he got notice. He can't say it wasn't delivered to him. I would also note in this particular case, he was on parole for delivery and possession of methamphetamine after only serving 13 months of a 30-month to 20-year sentence. And was found with, allegedly, at least at this point in time, 7.7 grams of meth in his backpack with a pipe. The court can obviously do a show cause, but if But quite frankly, I think if the court wants him to appear, I think he has to appear in person. I think the only way that's gonna happen is with a bench warrant.
All right, thank you, Mr. Cleo, is he on parole with somebody here in Otsego County?
He's on with Agent Davis. He had posted his bond. We had a parole violation with a hold. He had posted his bond. Violation was resolved, and then we found out that he had revoked his own bond. But apparently he's posted it again, so I'm not sure. I reached out to Agent Davis. I haven't heard back from her at this point.
Your Honor,
Yeah, go ahead.
if I could have one brief moment here. He said he's waiting to be let into the room. I'm wondering if he's in the wrong court.
Okay, yeah, I mean, that could be, there's nobody here, so.
I'm going to send him the proper ID here.
I'm sorry. He's not watched.
He should be logging in any minute, Your Honor. He did have the wrong ID.
Okay. All right, are you Mr. Splan?
Yes, sir.
Okay, all right. We do have Mr. Splan connected now. We have both counsels already put their appearances on. Mr. Brown, can you tell me where things are at with this file today?
Yes, I can, Your Honor. This case was bound over just about a month ago. I have been in contact with Mr. Splan. There appears to be of a recording that I would like to listen to and go over that with my client before we proceed further. But I have had conversations with him, and I believe we may be able to get this resolved. At this time, however, and until I can go over that recording, I would like to request a brief adjournment.
All right, thank you, Mr. Rowland.
Thank you, Your Honor. There is a plea offer currently out there for pleading to count one as a have to. Mr. Brown wants to go over that information with his client. People have no objection to a short adjournment.
All right, Mr. Brown, is there any reason why you wouldn't be able to do those things within the next 30 days?
30 days would be sufficient.
Okay, so we'll set this for a plea hearing status conference in about 30 days. So Mr. Splan, it's just important that you stay in touch with Mr. Brown so that you're ready to proceed at that time. The court will be asking you on that date of the next hearing whether or not you want to accept a plea or not. So I'll just need you to have made a decision by that time, okay?
Yes, sir.
All right, Mr. Rowland, anything else we need to address for the record today?
Thank you.
Mr. Brown?
No, Your Honor. Thank you.
Mr. Splan, did you have any questions at all?
No, sir. I'm all set.
Okay, that's all for today's hearing, and you're free to disconnect at this time.
Thank you.
Thank you.
Looks like that's your legal and Mr. Getting after this. Okay, Mr. Legal, can you go ahead and unmute?
Yes, Your Honor.
Thank you. And I think we have your client connected here as well. There we go. Okay, we'll go on the record in People versus Guinea. This is case number 236618. Record should reflect Mr. Guinea's present today by video. If I could have counsel put your appearances on.
Thank you, Judge, for the record. Michael, on behalf of the people.
Kyle Legal on behalf of Mr. Guinea.
Okay, this is set for a status conference in this case today. Mr. Legal, can you tell me where this file is at from your standpoint?
Sir, Mr. Guinea is going to enter a plea today. He would enter a plea to count 1. The second offense notice would be dismissed.
Okay, Mr. Roll, is that a correct statement of the offer?
It is your.
Mr. Guinea, were you able to hear that? I don't know if your microphone isn't connected. It doesn't look like you're muted, but we're not able to hear you. Might need to connect your microphone.
Can you hear me now?
Yes, yep. Were you able to hear what Mr. Legal said about the plea agreement in this case?
I did. I was. I heard.
Is that how you need to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. And Mr. Guinea, are you currently on any kind of probation or parole?
No, sir.
You understand that the maximum possible penalty that you could face for this charge, which is delivery of gabapentin, that is up to 2 years and or a $2,000 fine. Do you understand the maximum possible penalty?
I do.
With that in mind, what is your plea to that charge today?
I'm pleading guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And can you tell me what's going to happen to those rights by you pleading guilty today?
They won't be there? Go away?
That's correct. You're going to be waiving and giving up all of those rights. I just need to make sure that you understand that you have those rights and that you're going to be giving those up by pleading guilty.
Oh, yes, sir.
Okay. Has anybody threatened you with anything to get you to plead guilty today?
No, sir.
Has anyone promised you anything other than what we've said on the record?
No, sir.
Is it your own free choice to plead guilty?
It is.
Are you pleading guilty because you are guilty?
Correct. Yeah, yes.
So the date that I have for this is back in January 26th of 2023. Is that the right time frame?
Yeah, I believe so, yes.
And at that time, were you here in Otsego County?
I was.
While you were here in Otsego County, did you give or sell a controlled substance known as gabapentin to another person?
I did.
Did you have any legal right to do that at the time?
No, I did not.
All right, Mr. Rolla, are the people satisfied with the factual basis?
Yeah, Judge, I would ask though, for record purposes, that Mr. Guinea can confirm that it was sold for $50 at the time.
Mr. Guinea, was that transaction for $50?
It was.
Okay.
Thank you, Judge.
Mr. Legal, are you satisfied with the factual basis?
I am, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
We are not, thank you.
Mr. Legal
I am not.
and Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of a plea?
Yes, Judge.
Mr. Legal,
I am satisfied, Your Honor.
thank you. Mr. Guinea, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. Somebody from the probation department will be in touch with you, Mr. Guinea, for a pre-sentence report. It's just important that you follow up with that contact when they contact you. Are you just gonna get the information from Mr. Legal?
We can, Your Honor.
Okay. And then, Mr. Guinea, it's important, of course, that you stay in touch with Mr. Legal. We'll set this matter for a sentencing hearing and you'll be notified of the date and time of that hearing. Mr. Rolla, anything else that we need to address for the record today?
No, thank you.
Mr. Legal, anything else for the record?
No, Your Honor, thank you.
Mr. Guinea, did you have any questions at all?
No, sir. I'm satisfied.
All right, thank you. That's all for today, and you're free to disconnect at this time.
Thank you. Have a good day.
And Mr. Rolla, I got a message. Is Mr. Fenton handling the route?
Not that I wasn't aware he was gonna be here this morning.
Well, I got a message that he's asking to appear by Sue.
And again, I don't have any objection to that, the court doing that, obviously.
Okay.
He's been handling the case, so I think that may be appropriate.
Okay. All right, so that's set for 10:15. I don't see
Ms. Smith?
Ms. Smith in the waiting room yet, so we'll take a brief recess and then we'll come back.
All right.
looks like we're connected, but I just need to have Mr. Rao go into it.
He told me about 15 minutes ago.
Council, I've got you both connected along with the jail, and we're just getting Mr. Rao brought into the Polycom room there, so it'll just be a second.
Thank you.
Great.
Oh, okay. All right, Mr. Rao, are you able to hear me okay?
Yes, sir.
All right, so we'll go on the record in People versus Stephen Rao, case number 236629 and 6630. The record should reflect Mr. Rao is present today by video from the Otsego County Jail. If I could have both counsel put your appearances on, please.
We're fine for the people.
And good morning, Your Honor. I'm Shannon Smith on behalf of Mr. Rao.
All right, very good. We're set for a status conference in each of these files today. Ms. Smith, have there been any plea discussions, or can you kind of tell me where things are at from the defense side?
Sure, Your Honor, there have been plea discussions, and to be quite frank with the court, I need more time with my client. We just received some additional discovery that he and I just went over. I am asking the court if we could come back on December 18th at 9:00 a.m. I'm going to be in your courtroom that morning on another case as well, and that would give me enough time to be able to discuss this with my client in person, which is what I really need to do if the court would allow for that.
All right, thank you. Mr. Fenton, does people take any position on that request?
No objection.
Okay, I think that's reasonable given the number of charges, the fact that we have two separate files here. So Ms. Smith, we'll set, I don't know if I'm going to be able to give you a 9 o'clock time necessarily. I don't want to.
I have no problem. Anytime is fine.
Yeah.
It doesn't matter.
Okay. So we'll set it for a hearing on that date of December 18th, the time to be determined, but the court will send out a notice of hearing for that. And then we'll go forward at that time. Mr. Fenton, anything else that I can address for the people on this today?
No, not today. Thank you, Judge.
Ms. Smith, anything else on behalf of the defense that we need to address today?
No, I would just like to quickly let my client know I'm going to get in touch with him right away to go over more things.
Okay, very good. Thank you. That's all for today. Council's free to disconnect at this time, and I'm going to go ahead and disconnect from the jail as well. Thank you.
Thank you, Judge.
Yes. Who's did an advice or rights form? They should be on the table right over there. Thank you. I saw Mr. Clay in here. Can you, Deputy, can you let Mr. Roll up there?
December 6th at 10. Drug court.
The one that we just had.
Yeah, he's got a drug. That's what she means. She's gonna be here in person because he was unsuccessful from drug court. So he's gonna be sentenced on December 6th at 10:30.
Yes, we'll do it for December 6th.
Guys, wait, Judge.
Agenda.
Get your attention. I just stood up and you just, I'm like, okay.
Sorry.
But is that gonna be enough time?
Well, we'll find out.
Okay. I mean, that is a couple weeks, it looks like. I think she said the 8th, I think is what she said. Okay.
Mr. Clingan, are you ready with your 10:15?
I was just doing some paperwork signed for sure.
Okay.
Try to approach, please.
Yes, please. This is Ms. Jefferson, is that right?
That's correct, John. sir.
Ms. Jefferson, you can come right to the podium there, please, and we'll go on the record in People versus Jefferson, case number 236640. The record should reflect Ms. Jefferson's present here in the courtroom today. If I could have counsel put your appearances on.
For the record, Your Honor, my Colin Gaff.
Brian McLean on behalf of Heather Jefferson for purposes of, I think it's documented for a status conference, but it's gonna be a plea.
Okay, and so counsel has provided the court with the signed advice of rights form as well as a signed plea agreement form, and it looks like Ms. Jefferson will be pleading guilty to count 1, and the charges and enhancements will be dismissed. Is that correct?
In addition, and this isn't part of per se this plea agreement, but Ms. Brooker has agreed that once this plea is accomplished today, the 23-41989 ST currently pending in front of Judge Cooper in the district court would also be dismissed. So not written on the sheet, but part of the plea agreement with a different prosecutor. So for purposes of the plea taking, Your Honor, we'll acknowledge that we do have a blood result from the Michigan State Police indicating 236 nanograms per milliliter of methamphetamine in the system, which is obviously more than what's needed for the statutory requirements. So just to kind of streamline the process a little bit.
Thank you. Mr. Rolla, is that a correct statement of the plea agreement?
It is, as I understand it, Judge.
Okay. So Ms. Jefferson, have you had a chance to talk to Mr. Clayton about this plea agreement?
Yeah,
And what we said here today in court, is that the same as what you discussed with him?
yes,
Is that how you want to go forward?
yes,
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
yes, Your Honor.
Ms. Jefferson, are you currently on any kind of probation or parole?
No,
And you understand that by pleading guilty to count 1, which is operating while intoxicated as a third offense, that the maximum penalty you could face would be up to 5 years and or a $5,000 fine?
yes, Your Honor.
With that maximum penalty in mind, what is your plea to that charge today?
Guilty.
So I know Mr. Clayton went through the advice of rights form with you, but I'm going to go through your rights directly on the record here as well. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all of those rights?
Yes, Your Honor.
And can you tell me what's going to happen to those rights by you pleading guilty?
Given them all.
That's correct. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you'd have to go to the next higher court, Court of Appeals, and ask them, and they could say no, and that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we said here in court?
no, sir.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty?
Yes, Your
So this looks like happened on April 23rd of 2023. Is that the correct date?
yeah,
Okay. That's what the report says. Do you have any reason to doubt that or think it's wrong?
no,
Okay. On that date, had you consumed some methamphetamine?
or before,
Okay.
yeah,
Prior to that?
yes,
And while you were still under the influence of that substance, did you drive a vehicle on Mill Street, in the area of Mill Street and I-75 here in Otsego County?
yes, Your Honor.
At the time that you were operating that vehicle, at your previous use of methamphetamine or any other substance, were you under the influence of that substance such that you weren't able to safely operate that vehicle and normally operate that vehicle?
No,
Well, and I think for the purpose of the statute, methamphetamine, as we all know, is a Schedule 1. Any one nanogram would be more than enough. She was 236. So do you acknowledge that we did receive
Yes.
a report from
Yes.
Michigan State Police? You have no reason to doubt the truth or
Right.
that report that you did have
Right.
that amount of methamphetamine in your system.
Yes.
Were you previously convicted of the offense of operating impaired in the 56A District Court in Eaton County about around 2010?
Yes.
All right, and were you again convicted about 2013 in the 12th District Court in Jackson County for operating impaired? Yes, okay, all right. So I believe venue and jurisdiction sound gives a factual basis for operating presence of controlled substance, which is still a 625 violation. The prior convictions are noted and requisite for the plea to the third offense. I'm satisfied as venue jurisdiction of factual basis with enhancement.
Thank you, Mr. Rolla.
You were satisfied, Judge.
Thank you, Mr. Rolla. Are you aware of any threats, promises, or inducements other than what's been placed on the record?
You're not.
Mr. Clayton.
We're none.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in taking of this plea?
Yes, Judge.
Mr. Clayton.
Satisfied.
Thank you. Ms. Jefferson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. Before you leave today, you're going to meet with Mr. DeLeo to set up a pre-sentence report. Just make sure you follow up with him, and of course, stay in touch with Mr. Clayton. We'll send out notice of the date and time of the next hearing to you and to Mr. Clayton.
Okay.
Thank you, Judge.
Greg, are you ready with your client?
Yes, sir.
This is People versus Sanders, case number 236622. Record should reflect Mr. Sanders is present here. If I could have counsel put your appearances on.
Patrick Craig on behalf of George Sanders, Jr.
Do we have a resolution on this file?
Do, Your Honor, if I may approach it, assign my rights.
Thank you. And Mr. Pagel, can you state for the record what the terms of the agreement are?
The defendant will plead guilty to count 1, operating while intoxicated, third offense, and count 2, open intox will be dismissed.
Thank you, Mr. Rolla. Is that a correct statement of the plea offer?
Yes, Judge.
Mr. Sanders, have you had a chance to talk to Mr. Fragel about this plea agreement?
Yes, I have.
And what we've said here in court, is that the same as what you've discussed with him?
Yes.
And is that how you want to proceed today?
Yes.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Sanders, are you currently on any kind of probation or parole?
No. Just with this.
The bond.
Bond conditions, okay. And you understand that the maximum possible penalty that you could face for operating while intoxicated as a third offense is up to 5 years in prison and or a $5,000 fine. Do you understand that?
Yeah.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty, right?
Choose to plead guilty?
Yeah.
Okay.
Okay. I'm going to go through your rights with you. I know Mr. Fragel probably went through those on this written sheet, but I'm going to go through them with you as well. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at the trial yourself if you want it. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you have to go to the next higher court, the Court of Appeals, and ask them to hear your case. If they said no, that would be the end of any appeal. You understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anybody promised you anything other than what we said here in court today?
No, sir.
Has at your own free choice to enter this plea.
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
This happened on September 6th of 2023. Is that the correct date?
Yes, sir.
On that date, had you been consuming some alcohol?
On that date, yes, sir.
Okay. And after you consumed the alcohol, did you operate a vehicle on I-75 here in Otsego County?
Yes, sir.
And did you have any blood or breath tests to determine the level of alcohol in your system?
Yes, sir.
Do you know what that result was?
0.18 was the breathalyzer and the blood was 2 point something. I don't actually.
0.24.
Okay. Do you have any reason to doubt the accuracy of those tests?
No, sir.
Had you consumed enough alcohol that you believe that your ability to safely and normally operate that vehicle was affected?
Yes, sir.
Mr. Rolla, are the people satisfied with the factual basis?
Judge, the court's gonna have to go over his priors.
Oh, I'm sorry, forgot that. Mr. Sanders, were you previously convicted of operating while intoxicated back in 2013 in Dearborn Heights?
Yes, sir.
And then all the way back in 1984 in Wayne County?
Yes, sir.
With that, Mr. Rolla?
Yes, Judge, thank you.
Mr. Fragel, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Fragel.
No, Your Honor.
And Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in taking of this plea?
Yes, Judge.
Mr. Fragel.
Yes, Your Honor.
Thank you. Mr. Sanders, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you make sure you stay in touch with Mr. Fragel prior to that hearing. And then before you leave here today, you're going to meet with Mr. DeLeo from probation and parole to set up a pre-sentence interview.
Okay.
Thank you.
Thank you.
I don't care.
Okay.
Judge,
All right.
would it be possible to have a conference?
It's regarding a form, Judge, that we have, so.
Yeah.
Short recess. The next hearing is not till 10:45, so we'll be great.
And that
court. This situation isn't your run of the mill, if there is a run of the mill, OWI third. Just a very, very odd situation with the medication issue being taken in the daytime instead of at nighttime. She did pose a significant risk. She understands that. And again, I would just ask that the court hold jail time in advance. And I know you've already approved the transfer, so thank you for that. And all the other recommendations appear to be appropriate to me. Thank you.
Thank you, Ms. Murphy. Anything that you wanted to say today?
I wanted just to say that I am very sorry for what I did. And I realized that I could have killed somebody else, myself. And I'm very, very sorry. And I'm grateful for the opportunity to do sobriety. I really appreciate that opportunity.
I did review the report, so I'm familiar with what happened in the circumstance. There's also a lot of information in that report about your background and your history as well. And obviously, substance use has been an issue for you in different ways for a long time. And although this situation didn't involve alcohol, as you know, as a medical professional, it's every individual's responsibility to use their medications responsibly and in a way that doesn't pose a risk to other people.
Yes, sir.
And like you said, if you had injured or killed someone, an innocent person on the road that day, they don't care what your reasoning is, their lives are affected forever. And so I hope that going forward, number one, that you do take advantage of the resources that are offered to you in the treatment court program. So I hope that you take advantage of that and that you participate vigorously in that program. I think that in terms of the community safety, which is my main concern, your participation in that program is more important at this point than I think jail is. So the court's going to impose jail, but hold that in abeyance. If you stay on the right path, if you follow the requirements of the treatment court program, you may never have to serve that jail time. But if you don't, then I think at that point, what I need to look at is how can we keep the community safe for at least a period of time, and that is by incarceration. So I think overall the recommendation is well crafted. I think it addresses the hope for rehabilitation here, but also provides consequences to the extent that that doesn't work. So the court is going to place you on probation for a period of 2 years. The court's going to adopt as the conditions of that probation all the terms and conditions listed in the report. And the most important of which, of course, is to participate in that treatment court program and successfully complete it. Guidelines in this case are 0 to 9. The court is going to impose 9 months in the Otsego County Jail with credit for 2 days served. The court is going to hold that time in abeyance to be served at the discretion either of the supervising court or the treatment court program agents. Court is also going to impose $830 in a crime victims assessment, a supervision fee of $30 per month while you're on probation. Of course, that may be subsumed by whatever the fees are of the treatment court program, which the court is going to order payment of those costs as well. They don't have an amount, but the judgment should refer to payment of treatment court costs. Court costs of $325, reimbursement for the testing of $200, OUID reimbursement, and then a $68 state cost. You do have the ability to seek an appeal of the sentence and answer if you have your client just to acknowledge receipt and let me know once she's done that.
That's jail time was how
Nine months.
We acknowledge receipt of that notice of right to appellate review.
Okay, thank you. Mr. Roll, anything further for the record today?
No, Your Honor, thank you.
Sure.
Do you want this back?
Yes, if you could provide that to the clerk, please.
So, logistically, does she report immediately to Warrenton Hills?
Correct.
Okay, Waterford, I'm sorry, yeah. Okay, thank you, Judge.
Thank you.
Thank you.
Good luck to you going forward.
Thank you.
I know, but he really does.
Okay, ma'am, can you tell me your name, please?
Amy Perry.
Oh, what'd that say?
Okay, we've got Mr. Gilo connected. We'll go on the record in People versus Amy Perry, case number 236616 and 6617. The record should reflect Ms. Perry's appearing today by video from Otsego County Jail. If I could have both counsel put your appearances on.
Record, John, I call back.
Harry Gilo on behalf of Ms. Perry.
All right, both files are set for status conference today. I believe this is Ms. Perry's first appearance in circuit court on each of these files. Mr. Gilo, can you tell me where things are at with each of these, please?
Judge, we have a resolution to both files. So my client's going to plead guilty to count 1 in each file as a second offense. And the enhancements would be dismissed. That is the subsequent the second count would be dismissed, and the habitual enhancement would be dismissed.
All right, Mr. Roloff.
I'll move this. That's correct, Judge.
All right, thank you. Ms. Perry, have you had a chance to talk to Mr. Gilo about this plea agreement?
Yes, I have.
And is that how you want to proceed today?
Yes, sir.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Ms. Perry, are you currently on any kind of probation or parole?
No, I'm not.
All right. And under the plea agreement, you're going to be pleading guilty to 2 counts of resisting or obstructing a police officer as a habitual second offender. That means that the maximum possible penalty that you could face for each of those charges would be up to 3 years. Do you understand that?
I do.
With that in mind, what is your plea to each of those charges today?
I plead guilty.
So right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty today?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making this morning. If you wanted to try to appeal it, you would have to go to the next higher court, the Court of Appeals, and ask them to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here today on the record?
No.
Is it your own free choice to plead guilty?
Yes, it is.
Are you pleading guilty because you are guilty of each of these charges?
Yes.
All right, so looking at file 3236616, the date of that incident is listed as August 5th of 2023. Do you recall that day?
Yes, I do.
And on that day, were you present here in Otsego County?
Yes, I was.
While you were here in Otsego County, did you encounter an officer from the Gaylord City Police Department, an Officer Nagy?
Yes.
Was that officer wearing his uniform?
Yes, he was.
Were you aware that he was performing his duties as a police officer at that time?
Yes.
And did he give you some commands or did you physically resist? Can you tell me what happened there?
I was out swimming and they pulled me out of the water basically and said that I was intoxicated and that they were taking me to jail. And I didn't really say that I wanted to go, basically.
Okay, so so they arrested you? Did you physically resist them when they were trying to arrest you for intoxication?
Yes.
Okay. All right, and then the other file, 236617, the date indicated on that is September 7th of 2023. Do you recall that day?
Yes, I do.
Okay, and on that day, were you also here in Otsego County?
Yes, I was.
And did that incident involve a sheriff's deputy, Deputy Fox from the Otsego County Sheriff's Department?
Yes.
And same thing, was he wearing his uniform at the time?
Yes, he was.
And were you aware that he was there performing his duties as a police officer during that incident?
Yes.
Okay, and did that also involve some kind of physical resistance or what happened in that case?
Yes, it did. They just basically said to go to jail and I really didn't want to come. So I did resist, yes.
Okay. Had you previously been convicted of unlawful use of a motor vehicle back in March of 2023 here in the 46th Circuit Court?
Yes, I was.
Mr. Rolla, are you satisfied with the factual basis?
As to both files, yes, thank you.
Mr. Keel, are you satisfied with the factual basis?
Yes, Judge, as to both files.
And Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Keel, are you?
No, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Mr. Keel?
You've complied, Judge. Thank you.
Thank you. Ms. Perry, the court finds that your plea as to each charge is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each charge. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing and you'll be, someone from the probation department will be in touch with you for a pre-sentence interview prior to that hearing. Mr. Roll, anything else we need to address?
None to the people. Thank you, Judge.
Mr. Kilo, anything further today?
No, Your Honor. Thank you.
Okay. All right. Thank you, Ms. Perry. That's all for today.
Okay, thank you.
And then to the jail officer, if you could bring Ms. Day.
Okay.
Thank you.
This day going in now.
All right, ma'am, are you Ashley Day?
Yes.
Okay, we're on the record in People versus Ashley Day, case number 236628. Record should reflect Ms. Day is present today by video from the Otsego County Jail. If I could have counsel put your appearances on.
Thank you, for the record, my phone back to people.
Gary Gill on behalf of Ms. Day, excuse me.
All right, we're set for a status conference in this matter. Ms. Day, I received a letter from you indicating that you wanted to request different counsel. Is that correct?
No, that's not.
Okay. All right, Mr. Hilo, can you tell me where things are at with this file, please?
Yes, Judge, we have an agreement. We'd ask the court to sanction. She's going to plead guilty to count 1. And that's going to be as an habitual offender second. And the rest of the enhancements and or charges would be dismissed. Furthermore, as part of the plea, if the prosecution requests that she testify against any co-defendant, she's willing to do that and will accept that responsibility as part of this plea.
All right, thank you, Mr. Rolla. Is that a correct statement?
It is, Judge. Upon the request of the prosecution, should she be asked, she's provided truthful testimony.
All right, Ms. Day, have you had a chance to talk to Mr. Gilo about this plea agreement?
Yes, I have, Your Honor.
And is that how you want to proceed today?
Yes, I do.
Could you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. And Ms. Day, are you currently on any kind of probation or parole?
I am on parole right now.
Okay, so you understand that the plea today could result in a violation of your parole?
Yes, Your Honor, I already set my violation days for it.
Okay, so you've already addressed that?
Yes.
All right, and you also understand that because of your parole status, that could affect the amount of jail credit that you would be entitled to. And to the extent that there were any other penalties for violating your parole, that would have to be served consecutively to any sentence in this case?
Yes, Your Honor.
Okay. And then the maximum possible penalty you could face for this charge, which is possession of methamphetamine as a second habitual offender, is up to 15 years. Do you understand that?
Yes, Your Honor.
All of those things in mind, what is your plea to that charge today?
I'm pleading guilty.
I'm going to go through the rights that you have right now. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, I do, Your Honor.
And you understand that you're waiving and giving up all of those rights by pleading guilty?
Yes, I do, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, I do, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes, Your Honor.
And are you pleading guilty because you are guilty of this charge?
Yes, Your Honor.
All right. The information I have indicates that this happened back on September 18th of 2023. Is that the correct day?
Yes, Your Honor.
On that day, were you here in Otsego County?
Yes, Your Honor.
And while you were here in Otsego County, did you have possession of some methamphetamine?
Yes, I did, Your Honor.
Did you know that that's what that substance was?
Yes, I did.
Did you have any legal right to be in possession of any amount of that substance at that time?
No, I did not, Your Honor.
Thank you. Mr. Rolla, are the people satisfied with the factual basis?
What's going to need for the enhanced purposes required?
Oh, sorry. Miss Day, were you previously convicted of a larceny charge back in May of 2014 in Grand Traverse County?
Yes.
Okay. All right, with that, Mr. Rolla.
People are satisfied with Judge.
Mr. Gilo, in terms of the factual basis?
I'm satisfied, Judge. You have a factual basis.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Gilo.
No, Your Honor.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Mr. Gilo.
You have, Judge, yes.
Thank you. Ms. Day, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing at the court's next available date. You'll be notified of the date and time of that hearing, and also prior to that, you'll be contacted by probation for a pre-sentence report. Mr. Rolla, anything further we need to address today?
Not in this file, thank you.
Mr. Gilo?
Nothing further, Judge. Thank you.
All right, thank you, Ms. Day. That's all for today, and the court's going to go ahead. People versus Jared Martin, case number 236620. Mr. Martin, let's get her involved.
He is, Your Honor. I do have a step to appearance by Zoom if I'm in the brochure. Yes. And Judge Mike Clark said for Mr. Martin, obviously.
Now, so why they're not connecting, but in the time, I'm just gonna pass this for a minute and correct that, and then once they're good, once they pop up, oh, hold on one second, here we go. All right, we just need you to unmute Mr. Martin.
I'm here.
Okay. All right, we're on the record in People versus Martin, and Mr. Martin's joined today by video from Harbor Hall. This is set for a status conference, as well as Mr. Rolla will have a motion pending to vote on.
Judge, and on that note, thank you. Director Michael, on behalf of people, we were told and we were given information that Mr. Martin is in inpatient treatment. I don't know whether that's voluntary or involuntary. If it's the latter, then we're not going to have a concern about having his bond revoked. If it's the former and it's merely voluntary that he can leave at a moment's notice, then we may ask them, we do have our motion to have his bond revoked for failing to comply with testing as required as a bond condition.
All right, Mr. Flagstaff, can you kind of tell me where things are at from your side?
Absolutely, Your Honor. And that's an interesting point I'd not considered. I wonder if we couldn't stipulate that it be involuntary. Is that something that we could enter with an order that's not allowed to leave?
Well, I think what I would do is just add that as a bond condition. So if he leaves, then that would be a per se violation of his bond. And you would need to report it to the jail immediately or a bench warrant.
We certainly would not object to that approach, Judge.
And again, Judge, I don't have any problem with that. Again, as long as it's addressed, I'd rather you get help than not. But I want to make sure he actually gets the help, not just uses this as a, here's here today in court, gone tomorrow day.
Right, understood, and I totally agree with that. So Mr. Clagstad, if you could prepare a stipulation or order adding that a bond condition that he continue to participate in and successfully complete in the residential treatment program. And that if he were to leave before successfully completing that program, that he would need to report to the Otsego County Jail or bench warrant be issued for his arrest.
And presumably at that point, the people can simply seek a warrant rather than file another.
Right. Yes.
Yes, Your Honor, I'd be happy to do that.
Okay, so that addresses the bond issue. Mr. Martin, do you have any questions about the application that you're going to have now with regard to your treatment?
Good morning, Your Honor. No, I do not.
Okay. Then in terms of the status conference itself, Mr. Clagstad, how do we want to proceed on that?
Judge, we have begun the process of application with the Sheboygan County Sobriety Court. I apologize, Judge, they have two different courts, district and circuit level. I don't recall the titles of both, but it's the circuit court level. Idea being that it would be entering a felony plea, felony treatment court, felony consequences. I believe he's had the initial interview. So we are actually moving along in the process, but we've not had an answer this time.
Okay.
I guess we would
just move this out 30 days to get that arranged. It sounds like he's, how long is your treatment program there, Mr. Martin, at Harbor Hall?
I'm not 100% sure. I believe it's going 45 to 60 days, I believe is kind of recommendation as far as me completing the program.
Okay, all right, so I think 30 days. Do you have any objection to that, Mr. Roll?
No, Judge.
Okay, so we'll set it for a plea hearing status conference in 30 days to give defense an opportunity to get approval for participation in that treatment court. All right, Mr. Clagstad, anything else that we can address on this file today?
No, Your Honor, that's all.
Mr. Rolla?
No, Your Honor, thank you.
All right, Mr. Martin, just make sure that you stay in touch with Mr. Clagstad as we go forward so that you're prepared for that next hearing, okay?
Yes, Your Honor. Thank you.
Okay, that's all for today, and the court's going to go ahead and disconnect at this time.
Thank you, Judge.
Thank you.
Okay, thank you.
Mr. Blumberg, are you ready with your client's matter?
Right, Judge, thank you.
Court will call People versus Randall Swift, case number 236536.
Taking up the table here, so you need it. I can just scoop it, that's fine.
Okay, this is set for a status conference today. Mr. Blumberg, can you tell me where things are at?
I can, Judge. For the record, Elliot Blumberg, on behalf of Mr. Swift, who's standing beside me. We have come to an agreement with the prosecutor's office in regard to a resolution to this tragic matter, and I will provide the court my understanding of that in one moment, if I could. I got it. I got it right here. Can I approach, Judge?
Yes.
Judge, my understanding of the agreement is that counts 1 through 4 are all going to be dismissed. Mr. Swift will be pleading no contest to added counts 5 and 6, which be reckless driving, causing serious impairment of a bodily function. We are asking the court to accept his no contest plea because there is still some civil litigation pending in resolving this matter. I provided the court and the prosecutor with a copy of the statute that we are going to be entering our no contest plea under, and 2 pages of the police report, which I believe will give the court a factual basis to accept the plea.
Okay, so there would be 2 counts of.
It's 2 counts of reckless driving causing serious impairment of bodily function, contrary to MCL 2576263. I provided the court clerk with the appropriate statutory citation, as I've done to probation and parole, in return for the court's acceptance of the defendant's 2 no contest pleas. Then at the time of sentencing, counts 1 through 4 will be dismissed.
Do the people have any objection to the no contest plea?
Judge, even if I did, the court can take it in any case, there's civil liability, I would advise the court, that's a 5-year, $1,000 to $5,000 Class E felony offense.
I just need 1 minute here to review.
And there's mandatory vehicle mobilization per statute. Judge, with some assistance to the court, if you want to take it as a lesser included offense under either, under would be counts 3 and 4, that's also sufficient for the people's purposes. Per court.
All right, Mr. Swift, have you had an opportunity to speak with Mr. Blumberg about this plea agreement?
Yes, sir. I have.
And what we've discussed here on the record today, is that the same that you discussed with him previously?
Yes, sir.
And is that how you want to go forward today?
Yes.
You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Mr. Swift, are you currently on any kind of probation or parole?
No, sir.
Right. And you understand, as both the lawyers I think have indicated here, that each of these counts that you're pleading guilty to has a maximum possible penalty of up to 5 years in prison and or a $5,000 fine. Understand that?
Yes.
With those penalties in mind, what is your plea to each of those charges today?
Okay, that's sir.
And the court finds that given the nature of the charge in this case, and when I read in the police report, that a no contest plea would be appropriate for purposes of civil liability. But you need to understand, Mr. Swift, that even though this is a no contest plea, that you still have certain rights, and I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand that you have all of those rights?
Yes, sir, I do.
You understand that you're giving up and waiving all of those rights by pleading no contest?
Yes, sir, I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you'd have to ask the next higher court, Court of Appeals, to hear your case. They could say no, and that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead no contest?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
Absolutely not.
Is it your own free choice to enter this plea?
Yes, sir.
Right. So the court has what's listed as Otsego County Sheriff's Department report number 00-4257, as well as an affidavit probable cause that refers to that same complaint number. And so the court has had a chance to review that. The court finds that that would provide a factual basis. The court is going to mark that as Court Exhibit 1 and admit that to the file as a factual basis. Mr. Rolla, have you reviewed those documents?
I have, Judge, and we have no objection with being admitted into the record. In fact, we've asked that.
All right, Mr. Blumberg.
Yes, Judge, we would agree with that.
Okay. Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on record?
No, Judge.
Mr. Blumberg, are you?
I'm not.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Your Honor.
Mr. Blumberg.
I am.
Mr. Swift, the court finds that your plea is knowing and voluntary. The court is satisfied based on Court Exhibit 1 that there is a factual basis to support a finding that you are guilty of this added count 5 and 6. The court will accept your no contest plea as to both. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave court today, you're going to meet with Mr. DeLeo from the probation department to set up a pre-sentence interview. And just make sure that you stay in touch with Mr. Blumberg prior to that next hearing, okay?
Yes, sir.
Mr. Roll, anything further on this file?
Not in this file, thank you, Judge.
Plummer.
No, Judge, thank you.
Thank you. Okay, Mr. Brown, were you ready with Ms. Fox LeBaron's matter?
Yes, sir.
People versus Carly Fox LeBaron, case number 2366589.
John, I called people, Ray Brown, on behalf of Ms. Fox LeBaron.
There.
Your Honor, actually have a couple of letters here that were just provided to me. I can show those to the prosecutor.
Sure.
Yeah, Coach, Your Honor.
Yes. All right, I had a chance to review the letters that were submitted on behalf of Ms. Fox. Ms. Fox, have you had a chance to go through the pre-sentence report and talk to Mr. Brown about that? Mr. Brown, aside from those letters, are there any other additions, deletions, or corrections?
I know, Your Honor, no challenges to the score.
Mr. Rolla, do people have any additions, deletions, or corrections?
No additions, deletions, or corrections provided report the challenge.
Anything on behalf of the people for allocution today?
Judge, it's the first offense from the situation or recommendations under guidelines, United States 067 years. No, for 2 days credit now. Offense, it's a controlled substance possession matter. Obviously, once people see the letters, and there's no question that this Fox LeBaron may very well be a hard worker. And I don't like seeing people lose their jobs. I also see that she has a job waiting for her when she gets back, regardless of what the board does, although she would be starting out at a lower position. I don't know whether that's justice or whether that's an appropriate message, but in any case, that's at the court's discretion. Thank you, Judge.
Thank you, Mr. Brown.
Thank you, Your Honor. She's only 24 years old, relatively limited criminal history here. As the court can see from the letters, she is a very hard worker, steady employment. I believe her boss actually is here to help support her in this. This is an issue here. She had some issues growing up in her childhood that no doubt contributed to perhaps some of the ways she thinks. But I would ask the court to take those things into consideration when fashioning a sentence. This is a young lady here that has a lot of potential, a lot to look forward to. I would ask the court to put her on a term of probation so that she can be monitored. It is my guess that she is not going to violate that probation simply because she does have a lot to look forward to, and she has a lot of people that are backing her and supporting her. If the court is inclined to order any term of incarceration, it does not appear that there is an objection to release to work camp, and I would ask the court in that case to follow that recommendation.
All right, thank you. Anything that you wanted to say? All right, I did review the pre-sentence report, so I'm familiar with what your circumstances are. I'm familiar with this incident that brings you before the court here today. Obviously, I had a chance to review the letters that were submitted on your behalf. And, you know, given your age, given the circumstances here, I think this is the kind of case that the court needs to look at a rehabilitation forward kind of sentence. In other words, one that's going to hopefully give you the tools and some supervision going forward to make sure that you're on the right path and that you're going to stay on the right path, and provide punishment as kind of a consequence if you don't follow through with the rehabilitation goals. So I do think this is a good case for probation, even though it wasn't recommended, and with jail time held kind of over your head. So with probation in place, you're going to have some supervision, you're going to have some conditions that you're going to have to follow during the term of that probation. If you follow all those terms and conditions, you continue to work and kind of do all the stuff that you're supposed to be doing, and you may never have to serve that jail time. However, if you have problems or you don't follow through with the probation, then at that point, you know, we've tried the rehabilitation part of it. That's not working, so then it's time for the punishment part of it. So I think a combination of those two things is an appropriate way to address this. So the court is going to place you on probation for a period of 12 months. The court is going to impose all standard terms and conditions, including that you not use or possess any controlled substances or drug paraphernalia, unless it's, you know, prescription medication that's prescribed to you by a doctor or another qualified individual. The court is going to impose 90 days of jail with credit for 2 days served. The court's going to, as I said, hold that in abeyance, so you don't have to serve that up front. That's going to give you an opportunity again to go forward with the probation, to continue to work. But again, if there's any violations on probation, then that's when you would have to serve that jail. The court is also going to impose a crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, state cost of $68, and a supervision fee while you're on probation of $30 per month. So yeah, you do have 2 days of credit. You do have the ability to seek an appeal of this sentence, and Mr. Brown has kept that now.
Your Honor, she has signed acknowledgement of that. I'm tendering that to the court.
Mr. DeLeo, if you could just let Ms. Davis know this, you know, the standard terms and conditions of probation. And so, do you want? Are you going to touch base with her when she leaves here today, or do you want to have her contact Ms. Davis?
Ms. Davis will reach out to her once the probation is ready.
Okay, so Ms. Davis is the one that did the pre-sentence report. I think you met with her.
I did.
She's going to be in touch with you. It's important that you follow up with that when she gets in touch with you. Mr. Roll, anything further on behalf of the people today?
Just one thing, Judge. There's apparently the defendant was on PITA status out of Muskegon. Does the court want to have a copy of this be sent to Muskegon, or do you want my office to do that? How would you like to do it?
See, I have no idea.
They have to be notified.
That's not something that.
Whatever they're gonna do, they're gonna do, but.
I'm assuming that their probation, that she's currently on probation or agent.
Well, she's under PITA status probation, correct, Judge?
So I'm sure Mr. Leo, they're gonna get notice of this, right?
I believe she's on Skyler's status.
Okay.
It's what the report indicated, so.
All right, well, it sounds like that's facts you're gonna need to touch base with wherever your probation currently is. Does that work out? Okay. All right, that's all for today. Thank you. Good luck
Thank you,
going
Your Honor.
forward. Mr. Brown, is Mr. Reno here? Mr. Reno, if you want to come forward right up to the podium here, please. This is People versus Kevin Reno, case number 236631. Record should reflect Mr. Reno's present here in court today. If I could have counsel put your appearances on.
The record there, people, Mr. Brown, I think that's Mr. Reno.
Mr. Brown, can you tell me where things are at with this file?
Yes, Your Honor, I have spoken with Mr. Reno on various occasions, the last, being very recently. And there has been an offer made in this matter to basically plead to count 3 plus added counts 4 and 5, which would be joyriding as a habitual second and use of cocaine as a double, or dismissal of counts 1 and 2.
Okay, is that a correct statement of the plea offer, Mr. Cola?
I believe that's correct, Judge.
Mr. Reno, have you had a chance to talk to Mr. Brown about this plea agreement?
Yes, Your Honor.
Okay. Did you want to go forward with that today?
Yes, sir.
Okay. You raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Brown, I'm going to ask that you state for the record what the maximum penalties are for those additional counts.
Yes, Your Honor. For the joyriding as a second habitual would be 3 years. Use of cocaine as a drug double would be 2.
Have you had a chance to talk to Mr. Brown, and do you understand what those maximum possible penalties are?
Yes, Your Honor.
And then also 1 count of operating while intoxicated, that's a misdemeanor that carries with it a maximum penalty of up to 93 days and or a $500 fine. Do you understand that?
Yes, sir.
Are you currently on any kind of probation or parole?
No, yeah.
So with those penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask the next higher court, the Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've stated on the record here today?
No, sir.
Your own free choice to plead guilty.
Yes.
Are you pleading guilty because you are guilty?
Yes.
Mr. Brown, I mean, I don't have an amended information. I'm going to ask that you conduct a question of your client to establish a factual basis as to these charges.
Mr. Reno, on or about July 25th this year, were you in Otsego County?
Yes, sir.
And while you were in Otsego County, did you get into a vehicle that was not yours?
Yes.
And did you take that for what's commonly called a joyride?
Yes, sir.
Here in Otsego? At the time that you were doing that, had you used cocaine?
Yes, Your Honor. Very honor. Yes, sir.
And I'm not there yet. And after using cocaine, were you under the influence while you were driving around?
Yes.
You did not have any permission to use that?
No.
Or to have it?
No.
I would defer to see if Mr. Rolla has anything.
When you were out, where did you operate this vehicle? And was that on a public roadway or area open? Right, I think the court now has sufficient factual basis to accept defendant's pleas as to would be count 3 and then add 4 and 5.
Okay, thank you. Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
Judge, one additional thing, since it was as a habitual second, we need to add this prior on the record. For the joyriding, it was a second offense.
Right. Mr. Serino, were you convicted of possession of a controlled substance in Bay City back in 2018?
Yeah. Yes.
With that?
And with that, Your Honor, now the people agree the court has sufficient factual basis to accept also the defendant's guilty plea as to add count 4. Has complied with court statute as acceptance of all pleas, and were no threats, promises, or other inducements not placed on the record.
Mr. Brown.
I would agree as well to the factual basis. Court has complied with statute, court rule in taking pleas, and I am not aware of any promises, threats, or inducements that have not been placed on record.
Thank you. Mr. Reno, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date, time of that hearing. You're going to meet with Mr. DeLeo from the probation department before you leave today to set up a date and time for a pre-sentence interview. And then just make sure that you stay in touch with Mr. Brown before that next hearing date, okay?
All right.
Thank you. Reflect that Mr. Evans is present here in the courtroom today. We're on the record and case number 2059661.
For the record, my colleague, April, very Brown.
This is the date and time set for a sentencing hearing in this case. Mr. Evans, we had a chance to go through the sentence report and talk to Mr. Brown about that. And Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor, and no challenges to the scoring.
Mr. Rolla, do people have any additions, deletions, or corrections?
There needs to be a correction under the evaluation plan. I believe the guidelines should say 5 to 23 months, not 5 to 3. It's a typo.
Oh, I see. Any objections to that change, Mr. Brown?
No objection to that.
Other than that, no challenges as to changes, other changes to the body report, no challenges as to scoring guidelines. Thank you.
Anything for allocution today?
It's a situation where we're dealing with a drunk driving. We're dealing with a 3rd, 4th, and 5th felony situation. It's his 3rd controlled substance offense. There is I would also ask that the court, in addition to the recommendations that are in the report, order that the taser be confiscated and condemned pursuant to statute.
Mr. Brown?
Thank you, Your Honor. We did have a conversation with Mr. Edmond. He does have a lot of family support in his life. He has a significant other, a 6-year-old daughter that he provides for. It appears, speaking with him, that his mother is very supportive of him as well. He does have clearly some issues that he needs to deal with. Maybe the people that he hangs around with are pretty bad influences, but he does have some employment history. He's working at United Plastics in Flint and is not that old, so he does have some potential here. He advised me that he would like to go back. He was a dropout in 11th grade, would like to go back and hopefully get his GED. This being 34 years old, and he does have quite a criminal history here. This might be the most serious thing that he's facing as well. And hopefully with the advent of this and some of the things that he's facing, and most importantly, it doesn't just hurt him, it hurts the people that are his loved ones and depend upon him, mostly his 6-year-old daughter. So I'm hoping that this is going to register with him and sink in with him And he advises me that that is one of the most important things in his life, if not the most important, is his family and his daughter.
Thank you, Mr. Edmond. Was there anything that you wanted to say?
Yes, sir, Mr. Judge. First, I would like to say good morning, Your Honor. And first off, I want to say that I'm sorry, and I'm sorry to the court. And I apologize to you, Mr. Judge Mertz, for you even having to deal with me on this unfortunate situation. My time here has been very difficult for me and for my family. I have a daughter to look out for. She needs me to provide and to protect for her. And also my fiance. My little brother passed just this last Thanksgiving, Your Honor. And my mom is not taking that very well. She needs me there, Your Honor. If I have to do more time, Your Honor, I ask, can I please do my time on GPS ankle monitor house arrest? I am corrected and I am fully rehabilitated. I am a reborn Christian. The great guys here, Mike, Chris, and Josh, that comes in every Monday and Friday for church, has helped me out a lot and taught me a lot of things, Your Honor. I promise to get my GED and take NA classes. I do have work with my father at his restaurant as a line cook, and I also have a job waiting for me at Northgate facility, packaging, labeling, and basically just processing out on Corona Road in Flint, Michigan. And once again, Mr. Judge Mertz, I am very, very sorry.
All right, thank you. I did read through the report, so I'm familiar with the circumstances that bring me before the court on this case. There's also a lot of information in that report just about you generally, your history and background and so forth. So taking all that into account, along with what you've had to say here today and what the lawyers have had to say, a couple of things stand out to me. Number one, you're developing a pretty significant criminal history. And at some point, that's going to end up with you having guidelines that are going to, from now on, pretty much call for prison sentences if you continue to have violations. So if you're going to straighten things out, now's the time to do it, because you've pretty much run out of chances short of that. You've had 7 prior jail sentences, a few times on probation with 3 varying degrees of success. And so the court looks at, what are our options now to try and correct your behavior, because the previous things have not worked. I think reading the report, number one, I think a prison sentence is appropriate given your past history, but it sounds like you're available or eligible for the boot camp program through the Department of Corrections. I think at your age, given what you've indicated here today, that may be a good program for you to participate in. It's going to give you a chance to get out earlier than you otherwise would. It's going to provide a different experience to you. It's different than probation. It's different than just a jail sentence. And I think that may be something that helps you going forward. So the court is going to sentence you to the Michigan Department of Corrections for a period of 18 months that's as to all 3 counts 1, 3, 6, 18 months. As to counts 3 and 6, 18 months to 4 years in the Michigan Department of Corrections. You have credit for 84 days served. As to count 1, possession of analogs, 1 year in the Otsego County Jail, all those sentences to be served concurrent to each other with 84 days credit. Department of Corrections will provide me with a eligibility statement. The court's not going to object to your participation in that boot camp program. In addition, $340 in restitution payable to the Otsego County Clerk to be dispersed to Donzel O'Connor. Mandatory forfeiture and destruction of the weapon involved, $130 court costs, $130 crime victims assessment, court costs of $325, attorney fees of $350, DNA testing fee of $60 and a state cost of $204. I didn't indicate it already, all those sentences to be served concurrent to each other. You have the ability to seek an appeal of this sentence, and Mr. Brown did provide Mr. Edmund.
I did, Your Honor. I'm tendering that acknowledgement to the court.
Mr. Edmund, you are remanded to the custody of the state at this time. Good luck to you.
And one more question, Mr. Judge Mertz.
Sure.
Basically, I have to go to prison.
Correct.
Will I be going to boot camp?
I believe that you go to prison first, they determine whether or not you're eligible, which your report indicates that you should be eligible for it. And then they'll provide me with paperwork to sign, allowing you to participate in the program. That process can take a little bit, but that's, I believe, how it's going to work. That concludes the court's morning docket. Court will be in recess until 1:30.